Hey, we're back with Laughter in the Law, a podcast by Flexner Hauser Injury Law. I'm Jackie Hauser. This is a continuation of our discussion with Candace Seagroves. We have talked about her journey to law school and to taking the bar and the bar exam, and we cut it off there. And the good news is,
I am a lawyer.
and only one summer to do it. So I'm telling you, some folks do have to take it multiple times, and I really do. My heart goes out to them. It doesn't mean they're not intelligent. It just means
not.
They had a worse day than you had because you only sobbed for half the day. So anyway, let's talk a little bit about what you did after the bar, because you had worked at this law firm as a runner, and then you worked there as a paralegal, and you worked there, how many years before you went to law school?
So I was there before I went to law school, I was there about 13 years.
Wow.
And then I was there while I was in law school. And then I did return there after law school. Like after I passed the bar, I came back as a lawyer. So as you mentioned, I started there as a legal runner, just, taking things back and forth to the courthouse to get filed. Then I transitioned into a paralegal role. And then after that, I came back as a lawyer, and then ultimately made partner and went on my own.
Okay. They hired you as an associate.
They did. So I knew I had a good working relationship with those folks.
Yeah,
certainly. Yeah. I had been with them for a really long time, and so really good working relationship. And so I started working for them. Once you are done with law school, usually in your third year or right before you finish law school, you get a provisional practice license through the bar. So you're able to work under the supervision of an actual licensed lawyer. So I had started doing that. And so I was working with them. As soon as the bar exam was done, I started to work the very next week.
Yeah.
And then you don't get your results from the bar exam until like October-ish.
August.
Okay. So maybe it was, but I couldn't get sworn in for whatever reason. I didn't get sworn in
probably until then.
Until October.
Yeah.
Because you have to wait for your letter from the bar and all of this approval stuff. Yeah. So thank you. It's, I've really tried to block that out, You
don't remember the day you got your letter?
I don't. I just remember it saying I passed.
Yeah. Yeah.
That's the extent of that.
Cool.
So, but yeah, and so I worked for them, and then I started working for them, over the next several years. I mean, I was there for another 4 years.
Yeah.
As an attorney with them. And it was a really great experience. I did some criminal work in the beginning, which really got me heavily involved in litigation for the purposes kind of on a fly, not being able to prepare. And just learning to pivot pretty quickly. So that was really good experience. And then I started transitioning what the area of my practice was going to look like.
Yeah. And so tell us about how you decided to leave the firm. I mean, you got all these partners, you got an established practice, and you decided to leave that firm and just go out on your own, just hang out your shingle.
I did. And I think some of that was also prompted by COVID, right?
Okay.
I do think for my particular area of practice, that was kind of a pivotal moment. I had probably about 2 years into my practice, after I was an attorney, I had found, by way of a case that I had worked on, this kind of niche area as related firearm rights, specifically the way it was impacting, military and police and government personnel, and having the ability to possess a firearm if they had ever had some sort of mental health commitment in their past.
Okay.
Now, we have different laws and things that are in place now that would prevent some of what I help fix from happening again today. But it happened a great number of years prior to those laws being changed. And while many of those records were sealed, there was a federal law that passed in 2015 that ultimately then became a widely utilized, by way of clerical entries, et cetera, that caused a lot of those protected records to become not public, but attached to one's background.
Okay.
So if you had previously had firearm clearance or firearm approval or security clearances or even a TWIC card with say, a CDL driver's license or an explosive hazmat clearance provision with a CDL license, you could no longer renew those if anything came up on that background. So that was a really specific area that I started educating myself on and then did a lot of research about it. As you can imagine, it's a very politically charged area of the law. So we do have a statute that sets forth a path for resolving those types of issues, but merely because you can meet the statutory requirement doesn't necessarily mean that that's going to equate to relief.
Right.
As you know,
right.
A lot of that depends on, what judge you're in front of, what your opposition's position on the issue is going to be. So it's really more of persuading people based on feelings more than it is even statutory guidance. But nonetheless, I started doing that. And so that area of practice really just started growing. I had started doing guardian ad litem work. One of the attorneys that was in my firm had a really good working relationship with our, kind of like chief clerk at the time that was kind of over that. I got in on that list doing attorney work for those who were incapacitated, which kind of went hand in hand with me dealing with some of this mental health relief on this other area of practice. And then I built up a lot of experience in that area and the reputations. I took more and more days and then ultimately started doing that privately, and not just from a court-appointed standpoint, and then not just as a GAL, but petitioners, attorneys, and things like that. And so I built that area up as well.
What is guardian ad litem work? Tell folks what that is.
Yeah, so guardian ad litem work is where there is a party to a proceeding who isn't maybe of sound mind to make decisions about that particular litigation or wouldn't be able to maybe advocate for their own best interest. And so what you have to do is advocate for their best interest. And there's two different types of GAL work. So there's, your standard GAL work where you might have a minor who's involved and, they are incompetent just because of their age under the law. And so you stand in for them and you represent them like you do any other party. And then there's GAL work and guardianship proceedings, which you don't just stand in for them. You do stand in for them by way of what you think they would want you to advocate for, but you also have to tell the court what you believe to be in their best interest. So it's a little bit different on those hats that you wear. You're wearing two different hats in that particular situation.
And so with the guardian ad litem work, explain what the difference is between having a guardian appointed for the person versus for the property.
Yeah, so when you are having a GAL appointed, and this would be in a guardianship proceeding, like an incompetency proceeding, then you are going to have to stand in and make a determination if that person needs to be protected by way of their person, like their body, their physical well-being, or if they need to be protected just by way of their assets.
Maybe they have some assets that need protecting,
right?
And they're not capable of doing it.
Yes, like their home or their bank accounts or their retirement funds. Certainly this becomes an issue, particularly with the elderly population as they lose some cognitive abilities. Sometimes they don't have estate planning in place, which could sometimes negate that need. Or sometimes they do have estate planning in place, but the person that they appointed can no longer serve or isn't serving in the right fiduciary role.
Yeah. And I'd like to take credit for getting you involved in guardian ad litem work. I mean, I think it was me who did that. And just for the record here, because guardian ad litem sounds really fancy, but basically ad litem just means for this thing. So you're a temporary person set to be a guardian for whatever this proceating is.
Yeah, you're set to be a guardian. You're really set to be an attorney advocate for that proceeding. So I don't actually get to make decisions as a guardian will be able to do. I get to weigh in and argue to the court about what's going to happen as it relates to that particular person or property.
And so whenever you were a baby attorney, and, trying to, give you a little boost here, things to do, I offered you a guardian ad litem position.
I'll never forget, actually. I'll never forget. And I would like the record to reflect that I'm pretty sure she offered me like $200 or something.
I think it was $250.
Okay, I'm sorry. I stand corrected.
And for a baby attorney, we just say thank you whenever someone offers us money.
Right. Normally, that would be the case because there wouldn't be much work involved, except in this case.
Well, you made it more labor intensive than it had to be.
That's definitely not how it happened. But let's get into that.
The record will reflect that all you had to do was make a phone call and then show up in court.
I think you're going off script again. You're not allowed to do that. That's just me. I would just like to point out, that's a funny story. I think we should tell the listeners about that because it is a funny story. So Jackie calls me.
Whose version are they going to get?
They're going to get mine, which is the most accurate,
okay.
I think, of the two of us. So she calls me up and she says, Candace, hey, I need you to be the GAL attorney in an accident case, right? This young girl.
It was a minor.
That's right. This young girl is a minor. She didn't really sustain any injuries, but she's still a party to this action, and there's a settlement already in place, and we need a GAL appointed to approve this settlement. And it sounds, even a baby attorney recognizes how simplistic that is. And so I said, sure, I'd be glad to do it. And because it was Jackie, I probably would have done it for free. I mean, I just loved her so good.
And this was back in the dark ages whenever I was working for the defense.
That's right. You were working for an insurance, or you were defending an insurance company.
Because either way, we would need a GAL, whether I was defense or plaintiff. The minor needs a guardian. So. That's
right. And I'm going to make an independent recommendation and approve it, despite who any of the attorneys are.
Right.
And so she sends me. I get appointed by the court. She sends me the case file, and I contact this minor. And so I talked to her parents and talked to this minor. And at that point, I learned that there was an allegation that there was an injury maybe that was still ongoing. But there wasn't any medical evidence to back this up. And so I reviewed all the medical records, and the settlement I felt was very generous. And I talked to the parents about this. And so we were all set. Everybody wanted this settlement. I felt like it was in my client's best interest. And so we get it calendared and we show up for court. Well, first of all, I show up about 30 minutes early. And Jackie's not there. And I call Jackie and say, where are you? Do you remember this?
I do.
And you said, okay, it doesn't start for another half hour. And I'm like, oh, well, that would have been okay. So, and then we get there and the judge is doing calendar call. And of course, Jackie she has just decided to show up, and she is not actually going to do anything. I think she is going to make baby attorney do it all, even though baby attorney has not actually done this before.
Let me interrupt here. Jackie has done all the paperwork.
Okay.
Jackie has given all the paperwork to baby attorney to get signed.
Right.
That's all baby attorney has to do. Get the paperwork signed.
That's actually not, see, that's not true, because when it came time for calendar call, baby attorney had to answer calendar call. Baby attorney had to approach the court.
You're learning things.
I understand.
You're getting your feet wet.
I did it fine.
You did.
We got up to the tables, and Jackie's on one table, I'm at the other table, and the judge has confused me as like plaintiff's attorney.
This is where it gets funny, because he thinks you're representing. I don't think the judge understood what a guardian ad litem was.
He did not.
He really did.
He did, but
confused.
he did not understand that I was the GAL. He understood what it was. He did not understand that I was the GAL.
Yes.
He thought that I was the actual petitioner's attorney for them. And so what I'm noticing, though, is as the judge is reviewing the documents, is that Jackie is at her table with this really large briefcase and is pulling out all these papers and these files, and she's organizing them. And I remember sitting at my table thinking, what is she doing? Like, this is a settlement conference, basically. Like, it's going to take us 5 minutes, and she's over there, like, getting ready for a jury trial. I'm not sure what's happening. Yeah. And she just continues to be hard at work over there, just doing all of this stuff. And so the judge starts asking me questions. And it becomes clear that the judge does not understand what role I'm playing. And he's particularly asking for this settlement agreement. And I have now given the judge everything that I had had my client sign. And Jackie is not at all aware of this line of questioning. And so finally, I turn to Jackie and I say, hey, Miss Hauser, Judge is asking for a settlement agreement. Like, where is it? And she's like, oh, but I gave it to you. And I'm like, well, so we both stand up and we're like, Your Honor, everything we have, we've now given to you, including the settlement agreement. So the judge goes back through and he's like, oh, okay, I've got it. And so at this point, I realized that Jackie is not going to be very helpful to me during this proceeding. And so the judge asks me to stand up and give all of my things. And I do. And I say, Judge, my client is here. And so the judge asks my client to stand up, and I know this is coming, but Ms. Hauser doesn't. And my client says on the record there in the courtroom, everything's fine, Judge, except I do still have like this lump on my head. Well, suddenly Ms. Hauser has decided to stop her jury prep. And we have grabbed Ms. Hauser's attention. Ms. Hauser has now swung her head around and is looking.
That's the first I've heard of a lump.
Right, correct. I knew it was coming. And I can't help but to myself kind of chuckle. I thought it was kind of funny that Ms. Hauser was so taken off guard. But nonetheless, there's no medical evidence about it. The judge heard all about it. I did let the court, know, and the record did reflect that she did bring this to the court's attention. But there wasn't any type of medical evidence about this. There was no ongoing care. There wasn't anything. And so ultimately, the judge did approve the settlement. And that was that. So I would say...
And your first GAL court appearance was a success.
It was.
Because of me.
Well, I don't, yeah, okay. Well, if you want to see it that way. And I will tell you that I did collect my
It was $250.
$250. And did I ever do any more GAL work for you?
You turned me down after that.
I think so. Well, I think
I can always hope that maybe now you'll let me hire you for a GAL work if I need to, but you turned me down after that.
Yeah. It's funny how that would have happened.
I can't imagine
why. I don't know.
What you didn't realize, I wasn't preparing for a jury trial. I had other hearings that morning, and I was getting all my paperwork in order for my other hearings.
Okay, this just affirms my version of the story right here, that she had, in fact, checked out of this case and was already moving on. But nonetheless.
It's a great story. I love your first GAL experience, and I'm sure because of that, you are a much better GAL attorney today. Then we can look back on those first few experiences and see what we've learned from them.
Absolutely.
So let's wrap this up. So today you're solo.
I am. So I'm solo. So I ended up leaving the firm and opened up my own practice. I only do those two areas of practice. So I do firearm restoration and guardianship work.
Just very unique areas.
That's right.
That's all you do.
And that's all I do. And surprisingly, something that is vastly different, even though I do think many law firms are transitioning to this today, is I'm almost entirely remote.
Yeah.
My law firm, I deal with clients. I'm very engaged with my clients, but I don't have to see them. I do have an office, but I do not have to physically see them. We can do most everything electronically. Most everything can be done through phone calls. I have a client management system that I automate a lot of that stuff. And now with e-courts where we're e-filing, and then with WebEx where we're doing courts remotely, it makes it not only convenient for me and my staff, but it makes it very convenient for my clients, which I know that they greatly appreciate.
Yeah. So many people, I am finding more and more, people are not per se, let me make an appointment and come and talk to you at your conference room or in your at your table.
Right.
They, can't we do this by phone? Can't we do this by Zoom? And even your staff is virtual. So you don't even see your staff every day. You communicate with them, but you don't necessarily see your staff.
Right. I mean, I'm certainly very involved with my staff daily.
Yeah.
And, we have people manning the office and things like that. But no, I am not. I mean, I could be in a different county 3 days out of that week.
Yeah.
Right. And it gives me that ability to be able to do that. Additionally, though, not only only is it convenient in that way, but it's also incredibly efficient for the purposes of moving a case forward.
Yeah.
If you have to wait to have a client come in and sign everything and talk to you and then think about it and do all of that, like you're losing time.
Yeah.
Whereas if you can take it in and then kind of progress things forward, that makes it good for everybody. And when you have clients who are also working or raising children or, have 1,000 things on their plate, it makes it easy to be able to finesse their schedule as well.
And most of your hearings now are remote?
Most of my hearings are also now remote.
That's
and the
amazing.
court often prefers that,
Yeah,
right?
yeah.
And sometimes I need a special hearing date or I need a non-hearing date available. And so for them to do that, they're going to need it to be by WebEx because they may not have a courtroom available otherwise. And so and for clients who I have many clients who are out of state, and it just makes it very convenient for them because they don't have to travel in for that, which is an added expense.
Yeah, because you and I both remember the days, especially pre-COVID, whenever there was this thing called calendar call.
Right.
And all the attorneys showed up on a Monday morning and sat for calendar call. And you could sit there for hours waiting for them to work through the list of 20 or 30 cases or, how long is that going to take, Miss Hauser? 15 or 20 minutes. And how are your parties here? Yes, sir. And blah, blah, blah. And then they go on to the next, how long is that motion going to take? 10 minutes. And how long? And it was just an insane waste of time.
Right.
And once COVID hit, we realized we actually could schedule hearings as opposed to everybody show up on a Monday morning and then schedule them from there. Well, Hauser, you're going to go at 11:30, and Seagroves, you're going to go at 12:15. And why don't we just do that ahead of time?
I know. It's funny how COVID changed things. It was like nothing could be, it's what rolled out e-courts. It's what rolled out WebEx. We can never have hearings outside of it being in person. And yet here we are holding them outside of it being in person all day long.
Exactly.
So I think that's been, COVID certainly was detrimental in many ways to lots of things. I do think as it related to getting the legal system to become more efficient, it was certainly very progressive.
The system was either going to shut down or get efficient.
That's right.
So
it's amazing how quickly the system stepped into the ability to do that. So,
well, I love your story. I always sing your praises, and I give you a hard time, but that's because you're always such a good sport. If you had anything to tell somebody who's thinking about going to law school, because you and I both were non-traditional students, if somebody stopped you in the Walmart parking lot and said, hey, I hear you're a lawyer, should I go to law school? What would you tell them?
I still encourage people to pursue, if they have a passion for the law, I think they should pursue it. I do think a lot of people go into the law expecting it to be something that it just isn't. And I do believe that you and I had a very unique perspective of what the practice of law was because we actually knew what the practice of law actually was before we enlisted in becoming a lawyer ourselves.
Because it's not like television.
It is not like television. Television is it's great and it's drama intense and it's exciting and, all the things. And even courtroom, courtroom appearances on TV are not like that in real life. We don't get to approach witnesses in the state of North Carolina. We don't get to badger people the way it looks like they do on TV. All of that's like trumped up and, they don't really have any rules of evidence or, any of that. Not on TV. It just lets it all go.
Yeah.
So, but I do think there's still, even today, we have a lot of lawyers. I wouldn't say that every lawyer who's practicing wants to necessarily practice. And so there's other things that you can do with a law degree besides practice law, certainly. But I would encourage people to really get in there. I would actually say, now with nursing, they require you to become like a CNA as part of going to nursing school. I almost think, though, you should be required to work at a law firm before going to law school. Like the insight, even as a runner, into the operation of a law firm and to the practice of law is just so helpful. So many people I would hear pulling out and dropping off because they were like, this is just not what I thought it was. And so I think if there was some sort of entry into that, it would be very beneficial. So I always like to, I do have people approach me about that and say, hey, I'm thinking about it. And I'm like, hey, maybe get a job at the clerk's office, right? Maybe get a job at a law firm, like maybe investigate those options just to kind of see if that really is the path that you want to take. And it's not for the faint of heart. And I think you and I could both attest now that we are lawyers, it is still a constant jealous creature of our time.
Absolutely.
It's not something that you turn on and turn off. You're carrying the weight of your clients' problems and their issues and, things like that. And so, like I said, you need to do it if you have a passion for it. But it's not just a job.
I love it. Love it. That's a great way to end up. I love that. Thank you so much for joining in today. Thank you, Candace, for coming and spending some time with us. That was fun. Thank you for tuning in to Laughter in the Law, where we talk about the law with a lighthearted twist.